and gentlemen, thank you for attending my presentation. In my presentation, I will discuss first the benefits from acceding to the Choice of Court Convention for Indonesia. Second, challenges of implementing the convention in Indonesia. And finally, the steps that must be taken to implement the convention in Indonesia. The benefits of the Choice of Court Convention for Indonesia are, among others, first, the courts of Indonesian civil procedure do not oblige the parties to comply with their choice of court agreements. The two codes that were enacted by the Dutch colonial government provides that the principle of actor sequitur forum rei may prevail over the choice of court agreement, depending on the plaintiff's choice. For example, in the case of PT Indah Kiat Pulp versus Bank America National Trust Company et alia in 2008, the parties agreed to the courts of New York State as their choice of court and agreed to the laws of the state of New York. However, the Indonesian company Indah Kiat brought the parties' dispute to the Bengkalis District Court in Indonesia, although the same dispute was still pending in the New York court. The Bengkalis court exercised its jurisdiction on the ground that some of the collaterals were situated in Bengkalis. In extraordinary appeal, the Indonesian Supreme Court did not invalidate the jurisdiction of the Bengkalis court, although it annulled its decision because Bengkalis court applied the wrong law. This decision made by Indonesian courts has lowered foreign investors' confidence in the Indonesian legal system. The second benefit of the Convention for Indonesia is that the draft bill of Indonesian private international law that recognizes the jurisdiction of courts chosen by the parties cannot be expected to become law anytime soon. Therefore, the accession to the Choice of Court Convention may help enforce the parties' choice of court agreements in Indonesia. Another benefit of the convention is that it will convince foreign parties about legal certainty in Indonesia and efficient dispute settlement with Indonesian companies, as it is common that Indonesian parties make choice of court agreements with their foreign counterparts. Finally, the Indonesian government itself, in particular the Ministry of Law and Ministry of Foreign Affairs, are not against the idea of establishing international agreements with other states to recognize and enforce the judgments of foreign courts chosen by the parties, insofar as the courts have their seats in the states that are parties to the international agreements. However, there are also some challenges to the convention in Indonesia. Currently, it is not easy for the government to accede to international treaties in general. The amended constitution requires Indonesian president to obtain approval from the parliament when entering into international agreements that can affect the state's budget. The Choice of Court Convention, in my opinion, may fit the category of an international agreement that can affect Indonesia's state budget. That is because a judgment made by a court of another contracting state that is chosen by the parties may harm Indonesian enterprises, especially the state-owned enterprises whose assets and capital come from the state budget. Therefore, the accession to the convention requires approval from the parliament, which is not an easy process. The constitutional requirement did not exist when Indonesian government acceded to the New York Convention 1958, for example. Therefore, it was easier for the military government in 1981 to accede to the New York Convention 1958 only by virtue of a presidential decree. Although, in fact, the New York Convention posed the same risk of loss to the Indonesian state-owned enterprises due to foreign arbitral awards. The second challenge is that the choice of court convention may cause exodus of cases from Indonesian jurisdiction to foreign courts because, in practice, foreign parties often choose foreign fora, either foreign courts or foreign arbitration in their agreements with Indonesian parties. That can cause resentment among Indonesian judges who want to maintain their judicial authority and refuse to become merely enforcers of foreign judgments. That happened back in 1981 after Indonesia's accession to the New York Convention 1958. Indonesian Supreme Court refused to enforce foreign arbitral awards for 9 years and ordered lower courts to do the same. At that time, foreign arbitral awards were not self-executing and must be reviewed by the Supreme Court in order to protect Indonesia's interests. To face the challenges to the choice of court in convention, Indonesia must take the following steps. First is to make Indonesian courts favorable for foreign parties, to convince them to choose Indonesian courts instead of foreign courts in their contracts with Indonesian parties. Meaning that Indonesia must improve the low quality of its judicial process caused by the lengthy and costly process of enforcing contracts in Indonesia, as indicated in the 2020 World Bank's Ease of Doing Business Index. Next, the Parliament must be convinced that the choice of court convention can improve Indonesia's ease of doing business, or it is called now Business Ready Index, that is useful for Indonesian economy. In addition, the government must make necessary declarations provided by the convention to safeguard Indonesia's interests. Along with the choice of court convention, the government needs to accede to the 1970 Evidence Convention and 1965 Service Convention. The two conventions provide more efficient mechanism for Indonesian courts when serving judicial documents to and taking evidences from the parties abroad. Therefore, the accession to the Evidence Convention and Service Convention is important to support the implementation of the Choice of Court Convention in Indonesia. Thank you for your attention.
Thank you very much, Professor Kusumadara. Please have a seat. And we'd like to thank Professor Law for attendance today. Thank you very much. All right, ladies and gentlemen, now is our very interactive session. We're going to have some Q&As. So please feel free to just raise your hands if you have any questions for either of our panelists on stage, and join us online. Just feel free to ask your questions. And of course, our online guests, you can just type your questions through the Zoom through the Zoom chat feature. Thank you very much. So can I see?
As a functional alternative for the traditional punitive damages, so that it can be acceptable in many other contexts. And I think excluding multiple damages, the multiplied part of the multiple damages from the concept of what was the compensatory damages should be a point where there should be an international consensus, and about which there should be an uniform interpretation of the 2005 and 2019 conventions. And I'm wondering if Korea deviates from the broadly shared understanding of what compensatory damages, non-compensatory damages mean, then there will be a problem about the uniform interpretation or generally uniformity of private international law. And I'm also a bit cautious about making reservation, because reservation should be supported by a strong state interest. And I'm wondering if the multiple damages, the multiplied part of the multiple damages.
First of all, you have the two questions, and it's about uniformed interpretations by the international community, legal community, need to be made in the field of whether it is punitive or not. The second question is reservation. The clause need to be very cautiously adopted. Otherwise, it doesn't fit into the international convention. So first of all, I want to start with the scope of this convention, because in Korea, more than the 15 the acts prescribes travel damages. Even the Automobile Management Act contained of what is it, 5 times the damages, but the most of all travel damages prescribed them. At the outset, actually those acts start to cover competition law areas. Also, that covers labor-related the acts. So those areas actually it can be excluded the scope of the convention. But I actually object to this kind of movement in Korea, because it is punitive in nature. But it starts to include intellectual property law area. So in this sense, I think the infringement of intellectual property rights, the rising out of the breach of the contract, will be covered by this convention. So this is nothing to do with the discrepancy of the bargaining power between the consumer and the producers, or the labor, the users and employee and the employers. So in that sense, definitely uniform interpretation is needed, necessary. Another thing is, I didn't say the word reservation. I just used the word declaration. So we can go into the declaration, said this increased damage is not characterized punitive. So in that sense, we can just fit into the the what is it, the approach made by this convention. That's my answer. Thank you.
Thank you, Professor Lee, and also thank you, Professor Junyu Zhang, for your question. So do we have one more question? Anybody? Okay, that gentleman there.
Okay, yes. My question is for Professor Kusumadara.
Kusumadara.
So as a practitioner in Hong Kong, we do have clients who have operations in Indonesia, and we are drafting contracts for them. It's actually very natural for us to say, hey, let's use Hong Kong law, because number one, we theoretically and practically can't advise on foreign law. But at the same time, with the power of the conventions, we know that it might be beneficial to use local law as well. So what are the advice you would have for international practitioners to encourage people to say, hey, let's use other forum so as to resolve some of the challenges you mentioned about the exodus of cases and all that? What would you teach us Hong Kong practitioners on how to promote these conventions?
Very practical question, please.
Thank you for your question. Thank you. Thank you for your question. Actually, I myself is not a practitioner, but I see it from the theoretical and then academic point of view. When I read many judgments of Indonesian courts up to Indonesian Supreme Courts, it is really still the big issue, you know. In majority of the cases, Indonesian courts would like to try, and if because of the principle of actor sequitur forum rei. So let's say you have Indonesian counterparts in your agreement or contracts. And then the Indonesian parties bring the case to Indonesian courts. And most of the time, it is the trick for Indonesian parties for the cases to be accepted by Indonesian courts is that the contract issue is converted into the tort issue. So if it is tort, usually Indonesian courts will take it. Particularly if the case or they claim, the Indonesian parties claim that the tort takes place in Indonesia. Although actually it is based on contracts, but they say that because the contract is made based on fraud, for example. So it becomes tort. And it makes the Indonesian courts feel obliged. So actually, for example, in the case of the Indah Kiat that I just gave you the presentation, so there are the Indonesian courts, not only the lowest one, the Bengkalis one, but also the High Court, and then up to the Supreme Court, use so many reasons, legal reasons, to make the case, even it was still pending in New York, to be tried in Indonesia. So I think the biggest problem of this chaotic situation is that Indonesia does not yet have the act of private international law. We already submitted the draft bill many times since 1983. I do not know why, but Indonesian parliaments prefer to pass legislation that relates to public law. This, even we do have private law that still derived from the Dutch because it's private law. While public matters like criminal codes, etc., it has been amended recently. So in my opinion, once again, actually HCCH conventions are faster to improve the situation in Indonesian private international law in general. Like for example, now we ratified or acceded to Apostille Convention and others. And we think as well, actually, instead of choice of court convention, the ministers, the ministries that I mentioned earlier, Minister of Law as well as Minister of Foreign Affairs, actually now work very hard to convince the government to accede to the Service Convention and Taking Evidence Convention, because these two conventions do not affect, let's say, do not affect the state's budget. It is just procedural. So hopefully the government could just issue the government regulation or presidential decree, like in the case of Apostille. But choice of court convention, I think it is important, but once again, in my research, because I'm writing an article about this, there is, you know, a refusal from the courts because they are afraid that the cases will be taken by foreign courts. So they lost their judicial authority given by Indonesian constitution. So I think the background of all this chaotic situation is that because there is no yet the codified Indonesian private international law. I hope I could answer your question.
Thank you very much. I believe it's very clear and thorough explanation. Thank you. Thank you for addressing this question. And that's it for our Q&A session. We'd like to say goodbye to Professor Lee joining us online. Thank you for your time. And thank you, Professor Kusumadara. Thank you. Thank you for our panelists. Thank you. Please return to your seat. Thank you.